Whenever you're ready, counsel.
Your Honor, I'm going to begin by addressing the Fourth Amendment issues and then the full faith and credit issues, because without the evidence obtained in the search, which petitioner contends was illegal, there are no full faith and credit issues because there is no evidence and there's no need for Petitioner Gomez to justify that her possession of the marijuana was legal, because the marijuana would be impermissible evidence. So, moving into the Fourth Amendment issues. Respondent cites from two cases. So the first is Terry v. Ohio. As Your Honor asked respondent in an oral argument, Terry v. Ohio establishes only a right for an officer to pat down a suspect. So reaching into the pocket of Petitioner Gomez constituted an overreach of what Terry v. Ohio allows an officer to do. Now, it's also very clear in the opinion from Terry v. Ohio that the officer in that case did not reach under the outer garments of the suspects in Terry. And so because of that, Terry v. Ohio again establishes only a pat down. Respondent again conceded in their argument that the officer, it was unidentifiable to the officer what the small dense lump in Petitioner Gomez's pocket could have been. Right there decides the entire case, Your Honor, because when respondent concedes that the lump was unidentifiable, the officer then concedes that it was not a weapon. And because the officer knew that it wasn't a weapon, he therefore exceeded his stop rights that he had in Terry when he reached into the pocket, because he was not fearing for officer safety and he was not investigating a threat to his safety. And then as for Maryland v. Wilson, the only relevant holding of that case is that an officer can order a suspect out of the car, which is an issue that we've conceded. And for Utah v. Strife, that case is easily distinguishable in that it was a search subject to arrest, and that in that case the officer had a search warrant. The officer here had no such warrant. And so Utah v. Strife is again easily distinguishable and has really nothing to do with the case at bar. Now moving into the full faith and credit issues. Respondent first cites Hughes v. Fetter, but they read from Justice Frankfurter's dissent, which, Your Honor, as you know, is not controlling law. Furthermore, Hughes actually goes for petitioner. Hughes says in Hughes v. Fetter that unless there's a feeling of antagonism between two states' policies, full faith and credit needs to be given. There is no such feeling of antagonism, and so because of that, full faith and credit needs to be given. And moving into Allstate v. Hague and Baker v. Thomas, respondent really overreads into the court's language in both of these cases by saying they purport to say that those two opinions establish that laws are not transferable. But if that was really the case, Your Honor, why would we even have the full faith and credit clause that says that statutes shall be given recognition in one state, statutes of another state? That's the whole point of full faith and credit, is that laws, in many instances, are transferable. And moving into the specifics of each case, Allstate v. Hague said that Minnesota could apply Minnesota law because the parties in the litigation had worked in Minnesota and at that time lived in Minnesota. We don't have that here. Petitioner Gomez lives and works in Olympus. And Baker v. Thomas says that an injunction is not entitled full faith and credit because the second court where the injunction was attempting to be enforced did not consider all of the witnesses and the parties that could have testified in the litigation. So the cases that respondent cites in their full faith and credit argument are really not applicable. And so for these reasons, Your Honor, we ask that the court reverse the ruling of the 14th Circuit, because Petitioner Gomez, the evidence that was introduced should be excluded, and if the court finds that it should not be, under the doctrine of full faith and credit, she has immunity based on the Olympus law. Thank you.
Thank you. All right, guys, great job. All right, so the way I prefer to do this is maybe both of you guys give general advice, and then I'll ask each side to step out. Generally speaking, I just want to say you guys all did a phenomenal job. I don't do this for undergrads typically, I do this at law school, and you guys both teams would have put a number of the Duke law students to shame. So you did a really fantastic job. I'm going to ask to speak to the petitioner first. I'm going to have you guys wait out in the hall, and then when I'm done with them, I'll ask them to step out. If I can have everybody except for